Criminal Court Part 2.
Your case will be reset. All right. So, Mr. Feaster, you're here before the court on driving on a suspended or revoked license, and you have filed a pro se motion.
Yes, ma'am. That's correct.
All right. And so my understanding is this is this case 2020-CR08612. So this is for let's see. This you're arguing on behalf of the state is represented by Ms. Janvier, Ms. Sawana Janvier. Ms. Janvier, are you ready to go forward on this motion?
Yes, Your Honor.
All right, Mr. Feaster, you ready to go forward?
I am.
All right. So, Mr. Feaster, you filed this motion. So tell me what you're asking the court to do.
The only thing I would add to the motion that I filed is that the state has not provided a copy of a bench warrant, and the state has also not provided a copy of a citation, which would be needed for notice.
Okay. Are you on a bench warrant status? I mean,
I'm not, but I was detained and arrested, and there was no warrant for my arrest. Well, I haven't received a copy of a warrant. And
you were detained for the suspended or revoked license?
Alleged suspended or revoked license.
Okay, I'm not aware. I don't get involved until the case comes up to state court. So if you're getting like an officer stops you and he gives you a citation or you're arrested on that charge, there's not a bench warrant. A bench warrant suggests that you were given notice for trial or court and you missed that note. So it's not a bench warrant. You would have been arrested on an arrest warrant or warrantless arrest affidavit. So one of those two things.
And that warrantless arrest affidavit was not signed by a magistrate, nor was it reviewed or approved.
Okay. All right. So Ms. Janvier, so usually I don't have a pro se on the side. Okay, so this is what I have that you're asking for, Mr. Feaster, that you have that the case be dismissed for insufficient evidence, that there was a warrantless arrest affidavit, but it was not signed by or reviewed by a magistrate judge, that the state has not proven that you knew your license was suspended, that there was no notice provided to you of the failure to appear to court. But as I stated, unless you've missed a court date, a bench warrant doesn't issue. So essentially, you're saying that your license was allegedly suspended because of an FTA, a failure to appear.
I don't have any copy.
So you said you have no notice of an FTA, okay, and then you were never given a citation listing a service date under OCGA 40-5-56 showing that you were served. All right, so Ms. Janvier. Ms. Janvier, you know you're muted, right?
Did not
done half your argument and don't even realize.
Hit the button. Did not realize that. No, the failure to appear was the violation date was August 24th of 2019, and the suspension date was January the 30th. Excuse me, yeah, suspension was January 30th of 2020.
Okay.
And I'm just thinking. So the information for the citation, or excuse me, for the failure to appear would have been sent to the address that was listed on file. It was the responsibility of Mr. Feaster, if he has changed his address and is an incorrect address, to have notified the clerk that he had changed an address.
Do you know what address the notice was sent to?
The address is 6865.
May I rebut? I'm sorry.
Hold on. Okay. All right. Anything else, Ms. Janvier?
No, Your Honor.
All right. So, Mr. Feaster, so let me remind you that you're currently before this court, and the state is trying to have you convicted of driving on a suspended or revoked license. You have a right to remain silent and not give any evidence or testimony against yourself. You filed this motion pro se, which you have every right to do, but I also need to advise you that cannot be compelled to testify or give evidence against yourself, and any evidence or testimony that you give in this matter can be used against you in any subsequent prosecution of this particular case or any other case that may come up against you. So I need you to be aware of that. The state has presented an argument in this case, and you have stated that you wish to rebut that argument, but I do wish to have you understand that you have a constitutional right, and you're going to have to waive that right to present evidence in this case. So are you willing to waive your Fifth Amendment right against self-incrimination to present evidence?
I will not be presenting any evidence. I guess, may I ask a formal question of Ms. Janvier?
That's kind of weird, but okay, sure. It's usually if you have a question, it's for me, not for the state.
I do apologize. My question to you, Ms. Hayward.
I do apologize. That's okay.
Does the state have to provide a copy of said notice? and receipt of me receiving such notice. Because if I
You-
was to send something, I would send it certified, and I would have a copy of that.
okay.
Approved.
Does the state have evidence of in the form of the service something that was sent to Mr. Feaster or a witness to provide testimony that he was given notice?
The return mail notice that was returned on June the 8th and June the 16th, both of 2021.
That would be prior to me being
And-
arrested. That would be after I was arrested. I would need notice before my
And-
arrest.
And so we do have the return notice, Your Honor, but additionally, the state is not the authority that would have suspended Mr. Feaster's license. That would have been the Department of Driver Services.
Was this a
Because they
civil
would have used
claim,
the
not criminal?
Hold on, Mr. Chief. Hold
Okay,
on. No, this is criminal. So hold on. So my understanding is what you have notice of is that he failed to appear for a court date on August 24th of 2019. And then a suspension was issued by the Department of Driver Services on January 30th of 2020. Mr. Feaster was subsequently arrested on May 19th of 2020 for driving on a suspended or revoked license. And his suspension notice and the FTA notice both went to an address at 6865 Earlhurst Road, Atlanta. Is that correct?
That is correct, Your Honor.
And does the state have case law to support that notice to an address if that the defendant has the responsibility of updating their address with driver services, but notice to a previous address is sufficient?
The state would only submit that Department of Driver Services is the entity responsible for sending such notices, and the Department of Driver Services would only use the address on file. If the defendant had not changed that address, the Department of Driver Services can only send such notice to the address they have available to them. It is my understanding that they send 2 notices prior to actually suspending the license, Your Honor.
All right. All right. So, Mr. Feaster,
Yes, ma'am.
the where you go? There you are. So the FDA was granted in 2019 or was established in 2019. The suspension was done by Driver Services in January of 2020, and then you were arrested on May 19th of 2020. It is my understanding that the FTA notice would have gone to the Earlhurst Road address, and then the suspension would have gone to the Earlhurst Road address. And if those were previously listed addresses for you, then and you did not change your address, then the notice would have been proper based on the evidence that the Department of Driver Services had. They don't have a responsibility to track you down. We have a responsibility to update our driver's licenses if we move so that our license on our driver's license is the same as the one where we can receive notice.
Yes, ma'am. But without speaking on the facts, the state, well, the witness in this case, stated a citation number. The state has not provided a copy of that said citation. Again, if there was an FTA, I'm only asking that a copy of some type of warrant be established. I understand you saying that they sent notice, but I didn't receive notice. I'm arguing that the state has not presented any case law to rebut that. And if DDS is a separate entity, then I'm asking, is this a civil claim? And does DDS need to sue me civilly for anything that I violated with them? Because I don't believe I breached or.
Okay, so no, this is not a civil claim. DDS
Okay.
is a separate state agency.
Should they be listed as a witness? I'm sorry.
Okay, you could have subpoenaed anybody that you wanted to because in a motion. So had you subpoenaed someone or any records from DDS, those would have been accepted. This doesn't make it a civil claim. It just means that you have brought in a witness that is other than a witness that's presented by the state. In this case, though, I'm going to grant your motion. And there's a specific reason why I'm going to grant the motion. So you're asking for evidence of the failure to appear in the suspension, and the state has provided dates and an address, but they haven't given you anything that you can see, or they haven't provided any witnesses from the Department of Driver Services or even the police officer to establish how they determined that your license was suspended and at the time of the arrest. So at this time, the court is going to grant the motion to dismiss.
Gratitude.